The answer is probably. Most people that are charged with DWI have been pulled over and the police officer has brought them to the station where they've usually given them a breath test for alcohol. If there's a positive test over 0.08, then the police immediately issue a temporary license that's for 7 days. You'll only be able to drive for 7 days then, and then your license is revoked for the length of time that the Department of Public Safety determines is appropriate. Now, that length of time is based on a number of factors. If you have over 0.16 or double the legal limit, it lengthens the time of your driver's license revocation. If you have prior DWI offenses or prior license revocations, then that can lengthen the time of your driver's license revocation. In some instances where there's a test below 0.08, you may not lose your license just upon being charged. But your question asks, will you lose it if you're charged? And a charge is simply an allegation. It's saying the state is accusing you of driving while impaired. Now, most of the time in the United States, we have the presumption of innocence, and you don't lose your rights and you don't lose privileges just based on an allegation. But for DWI, a driver's license, the courts have determined that they want to take your license right away. And there is a process to challenge that and to get into court to have a judge determine if it was appropriate for the court to take, or for the law enforcement officer to take your driver's license. We handle many of those cases, and there are often ways that we can get a driver's license back relatively quickly while we fight your charges.